So Amy Coney Barrett, she did not totally agree with the Trump immunity decision. You had Trump v. U.S., the 2024 decision. Trump v. U.S. 2024. She did not totally agree. Amy Coney Barrett had made a point about bribery. She used bribery as a specific example. Not only is it against the Constitution, but it's also against federal code. She also mentions interlocutory appeal. So I'm just going to read straight from her opinion. I had took some notes here. I highlighted the parts that I thought were the most interesting, and I'm just going to read straight from her opinion so that way my paraphrasing doesn't get her opinion wrong. So according to Amy Coney Barrett, she concurs in part but also dissents in part. For the reasons I explained below, I do not join Part 3C of the court's opinion. When it comes to immunity, she defines immunity as the president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling. Before there's a final order, before there's a final judgment, you can appeal a court case with one of these interlocutory reviews. What exactly is an interlocutory appeal? It's an appeal of a non-final order issued during the course of litigation before a final judgment, and is generally rare, with the collateral order doctrine setting the rules for such appeals. So that's the collateral order doctrine is this. This doctrine allows appeals of interlocutory orders when they finally determine claims of rights separable from and collateral to rights asserted in the action and are effectively unreviewable on appeal from a final judgment. So carrying on, like the court, the dissenting justices and the special counsel all accept that some prosecutions of a president's official conduct may be unconstitutional. Properly conceived, the president's constitutional protection from prosecution is narrow. The court leaves open the possibility that the Constitution forbids prosecuting the president for any official conduct, instructing the lower courts to address that question in the first instance. The Constitution does not vest every exercise of executive power in the president's sole discretion. Youngstown Sheet and Tube Company v. Sawyer, 1952, which of course is when Truman tried to take over the steel mills because he said it was an issue of national security. Well, that was with the Korean War, wasn't it? Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier to prosecution in such cases. I would thus assess the validity of criminal charges predicated on most official acts, i.e. those falling outside of the president's core executive power, in two steps. The first question is whether the relevant criminal statute reaches the president's official conduct. Not every broadly worded statute does. For example, Section 956 covers conspiracy to murder in a foreign country and does not expressly exclude the president's decision to, say, order a hostage rescue mission abroad. 18 U.S.C. Section 956A. The underlying murder statute, however, covers only unlawful killings. Section 1111. The Office of Legal Counsel has interpreted that phrase to reflect a public authority exception for official acts involving the military and law enforcement. So then blah, 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 blah. These Article 2 concerns do not insulate the president from prosecution, but they do justify interlocutory. I know I'm not saying that right. Should I pull up? Nah, I'll do it later. That makes it more interesting, doesn't it? But they justify interlocutory review of the trial court's final decision on the president's as-applied constitutional challenge. See Helstosky. I do not join Part 3C, however, which holds that the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution of a president beyond the limits afforded by executive privilege. See ante at 30 to 32. I disagree with that holding. On this score, I agree with the dissent. I agree with the dissent. Consider a bribery prosecution, a charge not at issue here, but one that provides a useful example. The federal bribery statute forbids any public official to seek or accept a thing of value for or because of any official act. 18 U.S.C. Section 201C. The Constitution, of course, does not authorize a president to seek or accept bribes, so the government may prosecute him if he does so. See Article 2, Section 4. That lists bribery as an impeachable offense. Bribery is impeachable. Well, how do we allow super PACs? Yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution to make sense of charges alleging a quid pro quo. The jury must be allowed to hear about both the quid and the quo, even if the quo standing alone could not be a basis for the president's criminal liability. Therefore, thusly concluding the last sentence of Amy Coney Barrett's dissent from Trump v. U.S. 2024, the so-called presidential immunity decision. A president facing prosecution may challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. If that challenge fails, however, he must stand trial. If that challenge fails, however, he must stand trial. And that's Amy Coney Barrett's dissent of Trump v. U.S. 2024.